Uned-Derecho, videoclase.
Hello, thank you very much for being here with us. I'm Monica Herranz Ballesteros, professor on private international law at National Distance University. The class of personal data protection is going to be divided in two parts. The first one is in relation with the background and the context of the European data protection law. And the second one is going to be introduced by Professor Daniel Pelayo, and it will be focused on the new data protection regulation at the European level. So let's start with the first part of the class, the background of the European data protection law. If we talk about the background, we have to start with the European Convention of Human Rights, in particular with the Article 8 of the European Convention of Human Rights, that states that everyone has the right to respect for his private and family life, his home and his correspondence. In the second part of Article 8 of the European Convention of Human Rights, it states that there shall be no interference by a public authority with the exercise of this right, except such as in accordance with the law and is necessary in a democratic society in the interest of the national security, public safety, or economic well-being of the country, for the prevention of disorder or crime, for the protection of health or morals, and for the protection of the right and freedoms of others. So this article compels the states to refrain from any actions which might violate this convention right, but also the national authorities have positive obligations to secure the effective respect for the private and family right. In certain circumstances, so the jurisprudence of the European Court of Human Rights is going to be very important in order to interpret Article 8. If we continue with the background of the European data protection law, we have to take into account the Convention for the Protection of Individuals with regard to automatic processing of personal data. This convention was adopted in the Council of Europe in 1981 and is known as Convention 108. It protects the individual against abuse which may accompany the collection and processing of personal data. With this convention and after this convention, an additional protocol has adopted, and in 2001, and in this protocol there are new provisions on transborder data flows to non-parties, so-called third state, and on the mandatory establishments of national data protection supervisory authorities, in particular in Article 1. The principles of the Convention for the Protection of Individuals with regard to the automatic processing of personal data are in Article 5 of the Convention 108. For example, fair and lawful collection or the data must be adequate, relevant, and not excessive, as well as accurate. If we continue finish the background and continue with the European data protection law context, we have to start, of course, with the Treaty of the European Union, and in particular with the Article 6 included in the Title 1 of the Treaty of the European Union in the common provisions. Article 6 states that the Union is founded on the principles of liberty, democracy, respect for human rights and fundamental freedoms, and the rule of law, principles which are common to all member states. So the Union shall respect fundamental rights as guaranteed in the European Convention of Human Rights, adopted in Rome in 1950, as the result from the constitutional traditions common to the member states as general principles of the community law. We continue with the Treaty of the European Union, and we have to refer to Article 39 that directly mentions the Article 16, but now of the Treaty of the Functioning of the European Union. Article 16 of the Treaty of Functioning of the European Union states in particular that everyone has the right to the protection of personal data concerning them. So the European Parliament and the Council, acting in accordance with the ordinary legislative procedure, shall lay down the rules relating to the protection of individuals with regard to the processing of personal data by the Union institutes, bodies, offices, and agencies, and by the member states when carrying out activities which fall within the scope of the Union law and the rules relating to the free movement of such data. So compliance with these rules shall be subject to the control of the independent authorities. If we continue with the context of the European data protection, we have to take into account the Charter of Fundamental Rights of the European Union, and in particular Articles 7 and 8 of the Charter of Fundamental Rights. Article 7, as is well known, is similar to Article 8 of the European Convention of Human Rights, and it's about the respect for the private and family life. Everyone has the right to respect for his or her private and family life, home, and communications. Remember that in Article 8 of the European Convention of Human Rights, it's correspondence. Here is communications. Article 8 of the Charter of Fundamental Rights of the European Union talks about the protection of personal data directly. Everyone has the right to the protection of personal data concerning him or her. Then we have in the context, we have to mention, of course, the directive of data protection, the Data Protection Directive adopted in October of 1995. The aim of this directive was to harmonize the data protection law at the national level, and of course, if a member state already had a higher or more extended standard of protection before the entering into force of the directive, this standard could be maintained. Additionally to this directive, more detailed data protection provisions are often needed in order to achieve the necessary clarity in balancing other legitimate interests. So we have here several examples. The directive adopted in 2002, Directive on Privacy and Electronic Communications, or the directive adopted in 2006, the Directive of Data Retention Directive. And in order to establish data protection for the proceeding of personal data by institutions and bodies of the European Union, a regulation was adopted in 2001, and this regulation provides for the establishment of an independent supervisory body to monitor the application all of these provisions. With this, we finish the first part of this class. We studied, we talk about the context and the background of the European Data Protection Law. And as I said at the beginning of the presentation, Professor Daniel Pelayo will explain the situation, the new data protection regulation at the European level. Thank you very much for your attention.